I'm tasked with answering the question, if we are living in a world where class actions exist, do we have the right mechanisms in place so that they can actually be brought when they should be brought? And the answer turns out, no, there's very serious problems. One of which, I'll just start with the first one I heard on your list, is the offer of judgment idea. This, to me, represents everything that is wrong with the defense lawyer playbook. The idea that an offer of judgment could moot and terminate an otherwise meritorious class action is maddening, because it has nothing to do with what the case ought to be decided on, whether for the plaintiff or the defendant. It is pure gamesmanship and nothing more. If I bring a class action on behalf of a class representative who, let us say, bought a product that was supposed to have properties X, Y, and Z, and the label said it had properties X, Y, and Z, and it turns out it does not have properties X, Y, and Z, if we just assume those facts are either true or at least alleged, and that's what the case is about, and if we assume that there are 500,000 other people who bought that product who are all either going to win or lose together, if that's what the case is going to be about, it simply can't be right that sending a check to the class representative for $25 terminates the case and prevents it from being brought. Because if that is the reality, if that's the result, then we can't have class actions. So that can't be right. The idea that and this is the rhetoric that you'll hear from defense lawyers, and I'm not picking on Ian because actually and truthfully I haven't had this particular battle with Ian, although I wouldn't be shocked to see this rhetoric in any briefs that you file if we ever have this issue, because I've seen it from every other defense brief on this issue. The rhetoric you'll see is, I don't understand. We gave the plaintiff 100 cents on the dollar. He got everything he could possibly be entitled to. What's the problem? He said in his complaint.
I haven't had any rhetoric yet.
I'm gonna get to Ian in just a second on this point.
So the case says, everyone paid $25 for this product, which turns out to be worthless. Damages are $25. Defense lawyer says, okay, no problem. You got us. You win. Here's a check for $25. What's the problem, Your Honor? He got everything. He got everything he asked for. So how could the case not be over? We don't understand. It's only because of the vexatious, unreasonable conduct of his lawyer, Joe Siprit, that this case is still in court, because this money-driven, greed-based individual, Joe Siprit, wishes to continue prosecuting this case despite the fact that his client has already got his $25 back. To which the response is, well, how about sending that check for $25 to the other 500,000 people who are in the class? Because if you do that, you got me. Then the case really will be over, okay? That hasn't happened yet. But if it did, you're right. That is 100 cents on the dollar. But the result can't be that by sending the check for $25 to the one guy, the whole case is over, because that defeats the class action mechanism itself in the first place. The premise of class actions, to begin with, is that we are trying to target a situation in which damages are real and misconduct, I'm oversimplifying, and let's just assume the facts are clear, but misconduct, when it's there, is a problem that we want to stop and deter, and we want to get compensation in the hands of people who are entitled to compensation, even if it's only a small amount. Because if a corporation that makes widgets, takes an order for 10 million widgets from 10 million consumers and they don't ship any, and the cost of one widget is whatever, $10, we have a problem. No one's going to file a lawsuit. Very few people are going to file a lawsuit over the $10. So what? It's just okay that the corporation can keep the order or the money and not ship the widgets? No, that can't be right. So there's got to be a mechanism that's designed to address that. That's where class actions come in. That's the whole point. But these people don't grow on trees. It's very, very, very hard to find even one class representative for a class action, and that's another one of the reasons why the class action mechanism is broken, because of the sort of restrictions and rules that come into play for class reps, how they can be compensated, how they can be dealt with. Imagine the conversation you have with someone who bought one of these widgets or placed an order for a widget, and you say, all right, look, here's the deal. You can be a class rep in this case, and you're going to probably see your name in the paper tomorrow after we file. For the rest of your life, when someone Googles your name, the first search result they see is going to be that you were the plaintiff in some class action about widgets, which isn't bad. I mean, that just shows you're a fan of, consumer advocacy and you take, these things seriously. Good for you. But a lot of people don't like that being the number one thing that people see on Google for reasons that, we can all understand. Your grandmother's probably going to get subpoenaed. Not a joke, by the way. I mean, this is, again, defense lawyer playbook, like subpoena the girlfriend, subpoena the roommate, bring the grandmother in for a deposition, throw everything at these people, including the kitchen sink, to deter them from wanting to continue as a class rep. Defense lawyers will deny that that's the intent, but they'd be lying to you. That's exactly what the intent is. And frankly, again, I don't begrudge that, because if you're representing a client and the law says you can do these things, I guess you should. The problem is, if you're the class rep and you're thinking, okay, so let me get this straight. My damages are $10, so my grandma's going to get subpoenaed. I'm going to have to miss 2 days of work for my deposition. I'm going to have to theoretically be available for a third and fourth day for the trial. I'm going to have to go produce my bank statements, call my credit card company, and if I do all that and we win, the law says that I can't get more than like a few $1,000s. Are you crazy? Why would I ever do that? And that's a hard question to answer. The ultimate answer is because we need you. Because we need people who care enough about it that it may not be worthwhile financially. I can't tell people that it is. We will fight like mad to get them as much money as we can if we settle, and we will ask for a $20,000 incentive award or a $15,000 incentive award. And depending on the nature of the case, awards like that have been approved. Most of the time they're not at that level. Most of the time they're a few $1,000s. And frankly, the kind of person who is a class rep in these kinds of situations is the kind of person who just really cares about the principle, and God bless them, truly. Because we need people like that for the whole thing to work. But they don't grow on trees. And frankly, even if they did, I wouldn't know where to find them. I mean, if you've got 500,000 people who have been defrauded by the widget company, and they're all entitled to compensation, the whole point is that I'm not supposed to have to go out and find all 500,000 of them and convince them to bring $10 lawsuits individually. The idea is that we just need one. So the answer, to answer your question, the answer cannot be, well, what's the problem with sending the check and picking off the class rep? Because he'll just get 499, 999, thousand more, and if and when you do, we'll send them all checks. Like, that's not right. I mean, that defeats the whole purpose of class actions in the first place.